Good afternoon, everybody. Thanks to those of you who are joining us on Facebook today, too. Just to give you the lineup, I have an announcement and several updates, and I'll get to those in a minute. But I want to acknowledge it's been a while since we've been together. Now that the campaign and really the election are over, I want to thank the voters of Maricopa County for selecting me, and not only that, but the hard workers in this office to continue the work we've started. My commitment is to strengthen the ties between this office and the community and people that we serve. One thing I enjoy about campaigning is speaking to people about their day-to-day experiences, and that's a really good way to track their concerns and to stay on top of developing crime trends. And so it occurred to me during the campaign, why should this stop at the campaign? And so you're going to continue to see me out in the community a lot. And I've also asked a large division of our office to join me in the community, not at every event, but at neighborhood groups and block watches, community groups, and more, so that we can hear directly from the community on their concerns. And as we start to see results, and I'm sure we will, I'll report back to you on those. But the bottom line is this: thank you for trusting me and the people of the county attorney's office to keep you safe and to uphold the law. So with that, today I'm announcing the indictment of Michele Brimmer, Brimmer, on multiple counts relating to petition fraud. Now, I'm saying this not only for Ms. Brimmer, but also for any other case that I'm going to discuss today, that charges alone are not evidence. People are presumed innocent until proven guilty in a court of law. But the charges are as follows. Brimmer worked as a petition signature gatherer last summer and helped place Proposition 139, which was the Right to an Abortion initiative, on the 2024 ballot. An investigation has found that several signatures belonged to individuals who not only denied signing the petition, but said that they did not recognize the signatures as their own. Now, I want to make this very, very clear. The number of signatures that we are talking about that are affected in this investigation would not have made a difference as to whether this proposition got on the ballot. But that said, my focus is this: fraudulent petition signatures undermine the public's trust in our elections and will not be tolerated by this office. We're talking about a case that involved fraudulent signatures placed on an election petition. That is a crime, and those who engage in that conduct will be held accountable. So she has been indicted on the following: 1 count of fraud, schemes, and practices, Class 5 felony; 4 counts of forgery, Class 4 felony; 9 counts of false signatures on a petition, which is a Class 1 misdemeanor. And I can answer questions related to that when we get to the question and answer portion. The next announcement, as many of you know, Saul Bal, Saul Bal, is the individual who is accused of shooting 2 Phoenix police officers last September. One of those officers, Officer Zane Coolidge, died. Officer Matt Haney also was injured, in fact, badly hurt. Bal is charged with first-degree murder, and I have authorized my attorneys to seek the death penalty on Mr. Bal. Now, speaking generically about the decision to pursue the death penalty, I've said it before, and it continues to be true. Seeking the death penalty is the most difficult and serious decision that I make as county attorney. Without going into any specifics on the Bal case, I will tell you that some of the things that I consider in making this decision include the following: the next of kin's thoughts on the death penalty. I also have a senior group of attorneys who meet and pore over the facts, the mitigation, the aggravation, and other relevant information and make a recommendation to me. I also rely on expert opinions that might be provided to me, and of course the circumstances of the crime itself. I review every single case where there is a first-degree murder charge committed by someone 18 or older, And I want to make it clear that even though I do receive advice and recommendations, the decision is mine and mine alone. So trial in this case is scheduled for August of this year. Please keep in mind that those dates can and likely will change. Now, before I get to your questions, I'll give you one more update on the status of some of the legislation, not all of the legislation we're interested in, but some of it. Two bills, Senate Bill 1234 and Senate Bill 1412, are animal cruelty related bills. Both were introduced in the last legislative session but did not pass. My hope is that this year they will be successful. Let me be clear. These two bills strengthen our animal cruelty laws and give my prosecutors some of the tools they need to more effectively hold animal abusers accountable. 1234 adds clarity to the current law about what it actually means to provide food, shelter, and water for an animal. And just yesterday I was at the Capitol testifying about why these changes are essential related to this bill. This bill was offered by Senator Shauna Bullock, and we are very grateful that she's running the bill. And it did pass out of the committee with a do pass recommendation 7-0. Senate Bill 1412 amends the definition of domestic violence to include cruelty to a domestic animal. It designates a crime as an act of domestic violence. In doing so, it allows several things. One is crime victims can ask for an order of protection to protect themselves and their pets. And it requires the court to set release conditions for a defendant that protect the victim. We know from the statistics, and I know this as a prosecutor of crimes involving domestic violence and child abuse, that animal abusers are more likely to commit crimes like assault, property offenses, drug offenses, and they do so at higher rates than other defendants. I also support Senate Bill 1198, which allows us to bring tougher charges for killing a working animal, such as a horse or a police dog, and it raises that from the lowest level of felony, a Class 6, to a Class 4 felony. Another bill that we are squarely behind is Preston's Law. This is named after Preston Lord, who, as I'm sure all of you know, died at the hands of other teenagers. That just passed out of the Judiciary Committee in the House. It is House Bill 2611. If it passes through the legislative process and is signed by the governor, it would make swarming a Class 4 felony rather than a Class 6, meaning harsher penalties, and also would be a permanent felony. Swarming under the bill is defined as an assault on an individual by an attacker aided by two or more accomplices, also targeting that same individual, who are present at the scene. 2611 now goes to the House floor, and then of course it has to go through the Senate. We've also signed in support of Senate Bill 1144, which is the jail facilities excise tax extension. It passed unanimously out of committee. Maricopa County, as you may know, pays for its jails by collecting a jail excise tax. This tax is set to sunset or expire in 2027 if the voters don't choose to renew it. If it does pass, the Maricopa County Board of Supervisors can place the measure on the ballot so voters can decide whether to continue the tax, which is 1/5 of 1 cent. The bottom line with that is when we don't have a place for detaining arrestees, they get out, and we don't want that. So with that, I'll open it up to any questions you may have. Sir.
Question about the Michele Brimmer case.
Mhm.
These petitions.
Do you mind coming to the microphone?
Oh, sure.
Thanks.
Oh, sorry. Yeah. This is so people online can hear you.
Sure. My question is, were these petition signatures that were counted, and to your knowledge, how were they if they were potentially fraudulent signatures?
Were they counted? I believe they were handed in as a petition with the number of signatures required to get it on the ballot. But again, they were not of a sufficient number to draw into question whether that proposition should have ended up on the ballot.
You know what law enforcement agency investigated it, if you can say?
Our office.
Your office?
Yes.
One more question, if I can. Your office, specifically related to animal cruelty, has come under some scrutiny for the handling or not charging of the Brooke Scalero case, a Mesa woman. My question is, your office has told us that you did not have enough evidence to charge it beyond statements she made in both a journal and to police. My question is, could you help us and the public understand what may have been missing there, and if any of these bills you're mentioning could have helped?
Sure. There is a long-standing rule in the criminal justice system that you have to have more than simply a confession to a crime, that you have to have, not to use Latin here, but you have to have a corpus delicti, meaning you have to have not the literal body of a crime, but in this case, really, it is a body of the crime. And we did not have any sort of forensic evidence to suggest that what she indicated that she did, she in fact actually did. And without that, you cannot pursue charges. That doesn't mean that we don't think that what she wrote was not concerning or disturbing. Obviously, it was very disturbing. But this office is committed to holding people who would abuse animals accountable. Obviously, we're active in the legislation. We've also, in the past year or two, hired an investigator from another agency so that we could have that specialization within our own office and loan that investigative talent out to other agencies. So we are very committed to holding animal abusers accountable.
One more and then I'm done, I promise.
Okay.
The most up-to-date data we have, or you've presented in your data dashboard on your website for specifically animal cruelty cases, is from 2023. That says that there was 14 cases related to animal cruelty that were not filed, 12 that were. Could you help us understand what constraints your office may be up against that maybe would lend us to understand why that not filed number is bigger than that filed number?
You know, let me get back to you on that because that's different than the numbers that I'm aware of. And before I go into what those numbers are, let me just get back to you on that.
Sure.
But my information is that we filed far more than that. So.
Okay, sure.
Hey.
Hi, Bowen Overstoles, KTR News. A couple questions from the newsroom first. I was curious if you had a reaction to the firing of U.S. District of Arizona Attorney Gary Restaino by the Trump administration.
Yeah, you know, I've worked with Gary for the last, several years that he's that I've been in office and that he's been in that position. You know, I like Gary and he's a good lawyer, but that's just the reality of the position of U.S. Attorney. It happened 4 years ago when President Biden took over as well. He fired Trump's appointee to that position. That's the position of the U.S. Attorney.
Perfect, thank you. And then another question from the newsroom. Can you just talk about support or non-support of President Trump's general immigration and deportation goals by your office?
Well, you know, obviously immigration and deportation is outside the scope of what this office does. That said, I think I made it clear last year while the election was ongoing that I had grave concerns about the border policies as far as what we were seeing in terms of the criminal element coming across the border. We had for example, the dinner time bandits that they were not here illegally, but they were here on a tourist visa. We had fentanyl just pouring across the border, and so I am supportive of policies that control the border and who comes across it.
Thank you.
Hello. Is the mic on for sure? Okay, it is. My
Yeah.
photographer didn't have audio, so I was just checking on that.
It's hot here, so I can hear.
Okay.
Yeah.
A couple questions from the newsroom. They were hoping to get you on. There have been several reported cases of copper theft that's been impacting little leagues across the valley, community events. What can your office do to try and deter this or step in any way?
Well, I think we can issue a very clear statement that stealing copper, breaking into commercial yards or even residential yards of homes that are not occupied or occupied is a crime. It is a felony. Oftentimes the people that steal the copper do a lot of damage to other things, such as air conditioning units, to take those things, and so that also constitutes a felony of criminal damage. And cases that are presented to us involving that type of thing will be looked at, and people who do that will be held accountable.
And then, County Attorney, can you explain the reasoning on why the office chose not to pursue charges against Stephen Deloge after he was arrested in connection to the June 2022 murder of 39-year-old Dominic Daughtry.
Sure. As you know, the law in Arizona reads such that once a claim of self-defense is raised, it's viably raised, then the burden shifts to the prosecutor to disprove that beyond a reasonable doubt. There was sufficient evidence in that case that perhaps there was an element of self-defense such that we did not believe we could disprove a self-defense claim at this time. Obviously, cases, there's no statute of limitations, and you know, if additional information becomes available, we can relook at it. Wow. No, you promised. No.
Sorry about that.
Yeah. Reporters and attorneys with their one more question.
I know. I
yeah.
meant to ask about it, but I apologize for stepping away and stepping back. I feel like when it comes to a death penalty case, the public doesn't understand how it may work. To prove that someone should get the death penalty, is this a separate trial? Is this done after guilt has already been established? How does that work?
Yes, actually, it's really a three-part trial. So there's the initial guilt phase, and obviously you don't progress to the next phase if you're not successful in the one before it. So there's the guilt phase. If the person is found guilty of first-degree murder, then it proceeds to an aggravation phase. So there has to be a finding that there is a statutory aggravator. Examples of that include that there was a contemporaneous or another crime committed that was serious at the same time, or it was heinous, cruel, and depraved. And once there is a finding beyond a reasonable doubt of an aggravator, then it proceeds to the third phase, which is the jury deciding what the appropriate sentence is.
Same jury that sat in on the trial?
Typically, yes. Okay. There are exceptions to that, but typically, yes.
Thank you.
Okay. Thanks a lot. Have a good day, everybody.